Workers' compensation settlements take primarily two different forms. The first type of settlement is called a denial and dismissal. These typically occur in cases that are highly contested, cases where both sides agree that rather than have the injury officially recognized and memorialized, you're going to settle the case for some amount of money to have it dismissed, to have it denied, and have it not considered workers' comp. So that typically occurs in a case where if we have a client that perhaps it's a close call as to whether or not they were even an employee or not, or it's a close call in terms of whether the medical evidence really does show that they're disabled, or perhaps there's some other dispute about whether or not this case qualifies for benefits. It becomes a situation where going forward with a petition and having a judge decide it, and all the risk that involves, namely you could lose and get nothing out of your claim, or you could settle for an amount you agreed to, and in exchange your case is denied, dismissed, it is not workers' comp, but you're accepting and receiving a lump sum of money out of it. That's the first type of case called denial and dismissal benefits. They tend generally to be smaller amounts of money, not always, but generally they're not as valuable as cases that settle for people that are officially on workers' comp and have been on for some time. That doesn't mean they're not important parts of the workers' compensation system, and an important way you might receive compensation for something that you otherwise may get nothing for. So that's the first type of settlement, a denial and dismissal. The second type is called a commutation, or a lump sum settlement, or a lump sum commutation of your case, and that's typically a settlement that has more value to it. It's someone who is already officially entitled to workers' comp benefits, has been receiving them for some time, has been getting medical treatment, and for whatever reason, both sides determine that it's in everyone's best interest to settle the case. That can be for a number of reasons, because you can't stay on comp for more than 6 years if you're only partially disabled, which is most people. You can't predict the future often, and you don't know if you'll be able to collect that weekly benefit check up until the gate or the 6-year mark. And this is a lump sum of money that's paid to end your case forever and all time. And if you settle this way, via commutation, you will receive that lump sum of money. However, you will sign something that releases your employer and their insurance company forever from the case going forward. Your weekly checks will stop, and your right to have medical treatment, even medical treatment that's related to your injury, to have that paid for by the insurance company, that will end as well. And any future medical treatment you need will become your responsibility. So it's something that, of course, needs to be weighed out in terms of the benefit to you of settling your case in that manner. Sometimes it makes sense, sometimes it does not. But when it is something that makes sense and is the best option you have and is in your best interest, these are settlements that have to be heard and approved by the Workers' Compensation Court. There's a considerable amount of paperwork that you sign to get a settlement like that, and typically it means the end of your case forever. With some exceptions. Sometimes people settle their case by a commutation, but will quote unquote leave the medicals open, meaning your weekly check will stop in exchange for the lump sum of money, but the insurance company's obligation to pay for your medical benefits going forward remains open.